Good afternoon, everyone. I would like to say that we're going to follow through on the indicated notice that we mailed. The purpose of this meeting is to discuss dissolving the Murray Point Corporation pursuant to Minnesota statute section 302A721. That's really the only order that we're going to be discussing today. And I'd like to make a motion that we would resolve that pursuant to 302A721. As long as it's approved by the affirmative vote of the majority of our voting power, then the dissolution will be commenced. Resolution reads as follows: resolved that the stockholders authorized under Minnesota statute 302A721 the voluntary dissolution of Murray Point Corporation pursuant to Minnesota law. So I'd like to have make a motion that we would vote on this.
I'd second it.
You got to have objections and people need to speak their question.
Hold on. So we have a motion by David Nielsen with a second by Sue Scheiding. And now we'll move into discussion on the motion, to your point.
Okay, thank you.
And we have Shannon McKenzie, it looks like, joined us too. So, and again, because we're on Zoom, we need to be orderly in the sense that people talk. And so if you want to use the raise hand, or as Mr. Murray did there, you can just blurt out and we'll try to do it so there's some order. So Mr. Murray, go ahead.
I object to this, your proposal on this. Not all shareholders received your letter, for one thing. You did not have board approval on this. You're not following all the Minnesota statutes on dissolving a corporation. And you don't have everybody who's paid and not paid vote on that. So all the accounting has to be basically, the treasury has to be basically.
To me. Working on the paper.
Jen, do you want to mute your phone? Jen, do you want to mute it? You can turn your video off.
In summary, I think Paul's objection was to improper or an inadequate notice. There's an objection, I believe, to any members with outstanding dues voting, as that would be contrary to the current bylaws and or articles as amended. And furthermore, I don't believe that the present people who are acting as officers are actually the duly elected officers.
And this is a special shareholder meeting brought by shareholder David Nielsen, and it was given pursuant to the notice at least 10 days in advance. And so your objections are noted. And is there any other discussion?
I'd like to speak.
Yes, Mr. Iosset.
You'll say, if you don't.
Oh, I'm sorry. I apologize.
Okay. After this long, we should be able to pronounce our names. Anyway, my question is why? And what will this therefore lead us to? Sale of the point, establishment of a new corporation. I don't see beyond what today is supposed to accomplish.
Well, I'll just tell you what the plan is, and that once, again, assuming the requisite votes, once the votes taken are present to make the motion successful, the plan is to seek judicial oversight of dissolving the corporation.
To what end?
I guess I don't follow your questions.
Well, I mean, okay, dissolve the corporation, then what have you got?
Well, then I think we'll have what I'm going to generically refer to as a baseline, and then we'll be able to move forward in some way, shape, or form. I don't have specific answers to that, but what I will tell you is that everyone will have, or shareholders will have, notice and be allowed to participate in that. And so that's what the plan is.
I think the question's a good one, Mr. Van Bruggen. Is the intention to liquidate the assets of the corporation, which is kind of what it sounds like you're saying, but I'm not sure.
Well, and again, I'm trying to forecast into the future, and I can't give legal advice to everyone on this call. I've given my client legal advice, and we're going to proceed that way. So what I'm telling you is the intent is, again, assuming that there is a successful vote on the resolution, is that we will get into court for judicial oversight to the dissolution.
Yeah, is it possible to call you back?
For that to happen, you need 80% of the shareholders to approve on this, and where's the paperwork on that?
Well, I can talk to you for a few minutes.
And again, I guess I can talk about this now. So David Nielsen has powers of attorney, and we can just go through this right now. He has powers of attorney to vote Greg Honer's shares, Sue Scheiding shares,
That would be wonderful.
Maureen
Thank
Wilson
you so much.
shares, Jennifer Hubner shares, Jason Murray shares, Shannon McKenzie
No,
shares,
I know.
Ryan Tobin
I'm so
shares,
frustrated about
Dorothea
that because I've
Bates'
never
shares,
wanted that. And
David Tobin
So,
shares, and Donna
yeah.
Kerrigan shares.
okay,
Right.
And that is
okay, I
91
appreciate that
shares.
so much. Thank you. Bye bye.
There's Dorothea Bates and a couple other ones that have not paid their dues in years. So they're not allowed to vote. And according to our bylaws and standing rules, is everybody has to be paid up to par or in good standing with the corporation, and it has not. That's where, do you have paperwork from the CPA that's dictating that who's all paid, not paid, and the Treasury has gone through for an audit before this can even start or happen?
And again, that's the same objection I believe you already made, and your objection is noted.
It's in our bylaws that they have to be paid up. And the bylaws also state that the shares only are for voting. They do not have a value. Our value is in the 22 people that have a share or more shares now.
To put it a different way, Mr. Van Bruggen, I understand you're noting the objection and perhaps the intention is to fight that fight later, but it seems to me we would be putting the cart before the horse to take a vote on when there's an outstanding question about whether or not there are members who can actually vote at this meeting. It seems to be something that should be figured out prior to taking a vote, taking on an issue of substance. That's whether or not to dissolve the corporation.
Yeah, and again, we're not going to have that discussion today. I'll speak as an anecdote. I've been working, or I have knowledge of this for a lot of time, and respectfully to your clients, Kurt, they attempt to do anything and everything to keep this at a standstill and to maintain a monopoly through fear and mongering, and it's ridiculous. So we'll have that fight in court. If you want to say there weren't votes to do this, then we can talk about that when we're in court. So David Nielsen is going to be voting 91 shares, and we'll make the roll call. Is there any other discussion, I guess? Anyone else want to say anything?
I'd like to say something real quick. I know some of my cousins are on this call, and I'd just like to say that we were gifted these shares to be good stewards of the property. This was never a money-making deal for all of us shareholders involved. This was something that was supposed to be passed on generation after generation. We're supposed to take care of it. We're supposed to value it. It's not for us to be making money off of. It's really frustrating to see even what's happening here. I mean, you're pricing out your kids and your grandkids out of having something that is so special, and you're never going to get it back. So, when you vote right now, I really want you guys to think hard about what you're giving up. It's crazy that we're even doing this.
Thank you, Julie. Scott?
Yeah. I guess in the line with Julie, my dad, Robert Yosei, who gave me his shares, and my Aunt Marn Reese, who gave me her shares, often talked about Grandpa Murray, great-grandpa Murray, Asher, who founded the Point, who was he was a fine man. And I've studied quite a bit about him. I've known quite a bit about him. He was born only about 40 miles south of where I presently am. He was a self-made man, a lawyer, went to Rutgers. And I often think Grandpa is rolling in his grave at the bickering of the various cousins and throughout this entire family. I tell you what, there have been many times that I've felt like saying I quit because I'm tired of it. If people would act in an adult manner, why we need lawyers and all this stuff is honestly below the pale. I'm tired of it, and I'm just telling every one of you, put on your big pants on this thing. We are the Murray family. My middle name is Murray, okay? My son's middle name is Murray. I'm 65% Scottish, for God's sake, So I'm just saying, why can't we work this thing out? It seems like every time I've come together, the time I flew out to Fargo for the meeting out there, it was like I was always in the middle. Don't be in the middle, because you know what? You get hit from both sides. And I'm sorry, but I just feel that we need to follow after great-grandfather's example that he placed. He sent this place to be used by the family for generations, to be enjoyed equally by all people, and to have this bit about corporations being dissolved and then sold or whatever. I mean, it's just, it's infuriating, honestly. And I can't support this motion. There's no way, because it doesn't give me where you're going. What it says is you're going to go to court and you're going to pay a lot of lawyers a lot of money, okay? And I know sir, that you've been mispronouncing my name or whatever on this call, but the fact of the matter is yeah, you've made a lot of money off this thing so far, and you look at making a lot more. And the question is I don't like paying lawyers. I'm a dentist, okay? And David, you know dang well that you don't like paying lawyers anything more than that. You're a medical professional. So I'm just
and you're 100% right.
Can't you get this family together and quit this sides? I know, it's ridiculous. It really
Scott, is. Your point is well taken. And, again, I'm a lawyer. I'm not a shareholder or anything like that. But I agree with you 100%. And I can tell you that David, no one wants to see anything sold, but they want order. They want people to be able to, show up and know that they're going to be able to have a place. They're not going to be harassed. They're not going to be told you can't be here. They're not going to be physically threatened. We have been attempting, literally for the last 8 years, to facilitate this orderly. And we have gotten literally nowhere. At every step of the way, it's been met with more rhetoric, more just nonsense. And so I agree with you that if people could put on their big boy and big girl pants, we wouldn't be here now. And I can tell you the intent of my client is not to sell anything. It's to establish order so that everyone knows where they stand and everyone can carry on the legacy that our forefathers had relative to Murray Point. And that is the intent.
So with that, what's the point of dissolving a corporation? If you just want order, that doesn't mean you dissolve a corporation. That creates chaos. What's the point of dissolving a corporation? We've got bylaws. We have the corporation. That you're lying. I mean, that's not why you dissolve a corporation. Dissolving a corporation is the first step in selling. That everybody knows that.
Julie, how from your perspective has the corporation been running for the last 10 years?
It's been running just great.
It's okay. Well, that's where we disagree.
Yeah.
And
I don't know what do you think is chaos? We go out there every summer. We do projects. We enjoy the lake. I don't know what you're talking about.
And maybe you don't, but I can tell you if we want to move around the room and Sue and Noreen want to talk.
Well, I'd like you to answer my question about dissolving a corporation. What does that have to do with order?
There will be order. We're going to get
What's the
court,
difference though? If you don't dissolve it, there's going to be order. I mean, why would you dissolve a corporation? That's the first step in selling. Everybody knows that.
No, it's not true.
Very true. Totally true. There's no point in dissolving the corporation. What's the point of dissolving the corporation? What is the point?
I think that question was already answered.
No, it wasn't. You didn't answer it.
This is Shannon. What is the point of having two sets of books?
There's only one that I know of.
No, come on. That's a lie.
Well, I haven't seen yours. I mean, I don't know what you guys have. I know we're up to date and we're accurate. I know that.
Any other discussion?
Let's have a brief discussion, if I may. I agree again with what Scott said, and he's had a lifetime of his last name being mispronounced, so that's nothing new. But number one, you can't have two corporations running the same company. It's just unheard of, and it creates factions, it creates division. And for the number of years, it's been dysfunctional. There are a number of relatives that are afraid to go out there. And certain people that are there try to bully, push, harangue, and keep people from going there. I don't know what their ultimate goal is, but it's probably not the same goal as ours. My personal opinion is it's completely dysfunctional at this point. And we need to dissolve both corporations because there really shouldn't be either. If we go back a few years, Miss Mary Kay dissolved the corporation once, said we didn't need it. I reinstated it. Then she said we needed it. And now you guys decide to have a second corporation or the same entity, which any judge is going to look askance at that. So to say what Matt did, we want to dissolve both corporations and essentially start from scratch and see who wants to play in the sandbox with manners. And that's great. And if we have to go through the court system with judges to get to that point, we shall, because with all due respect, what Scott said, everyone's tried. It's gotten to the point where we can't even have a physical meeting. There's no control in this group. And so that's really all I have to say. I just want to preserve the point where all those that want to work together for a common cause can work with each other, not against each other, and move forward. Thank you.
Can we get in writing that you won't sell it?
Who's the 707? Can you identify yourself, please?
Telephone.
Yes, this is Brian Tobin.
Hey, Brian.
Hey, Brian.
Hi. Sorry I'm late.
Yeah, Brian, just to kind of get you up to speed, we're in discussion on a motion made by David Nielsen to dissolve the corporation. That had a motion and a second, and as I said, we're in the discussion.
Can we get in writing that this won't be sold, that it really is about reorganizing? Is that something we can get in writing, David?
That shall come. Okay.
No, it doesn't come. It's you get it in writing. You're not going to sell the property if you dissolve the corporation. This is about reorganizing. Remember, isn't that what you said? reorganizing.
All the rest of you combined, and I have no intention of selling the property. I don't know where that idea came from. That's somebody fear mongering, and that's just wrong. I have
So
no,
bylaws
I have no reason to sell the property.
And that
I
was
don't
one of the
know.
agreements
Number
anyway,
one,
so we
therefore
would all
I'm not
have
gonna
to
sell the
sign.
property. Sorry, Shannon.
Why are you trying to get rid of the bylaws then? If that's the being part of it, is you're trying to get rid of the bylaws. Right?
We made a motion to just get rid of the corporations and start from scratch to make a functional unit. That's it. You can argue about past history, whatever, but that's where we're at. That's what it's come to, and that's what's going to happen shortly.
This sounds like the very same thing that you had in that document several years ago, where you basically were using language to put yourself in a position of power to kick out anybody who disagreed with you.
I never said that, and you're making it up, Mary Kay, as usual, so.
No,
I guess we get that as evidence because we still have that piece of paper.
that,
And you probably wrote it in your own handwriting, Paul, so that's the problem. We can't have function, okay? So let's move forward with the meeting now.
There isn't two corporations. I wanted to correct you on that. There's only one corporation, one set of bylaws and standing rules, which you are ignoring totally on this. That's why I'm objecting again.
Well, if you're saying there's one corporation, then you're obviously ignoring the other corporation.
Well, the other thing that you said is people were fighting out there. You spent like 7 weeks out there last summer with you and your girlfriend and his kids. And you had everybody left you alone. I mean, there was no fighting out there, David.
I was not out there with any girlfriend or any kids, and I was not there for 7 weeks, so what you just said is...
It's true, David, because you showed up during our time there, and I let you stay in the lower cabin. I told you, this is fine. We agreed and we moved out. We let you stay there even though you came in during our stay, and it was worked out, and you were there for a long time. So you can, maybe 7 weeks is a little rough, but you were there a long time, and you came when we were supposed to be there, and we graciously let you stay.
So
This whole scenario is what brought us here today, and this is why we are where we're at.
Exactly.
All right. Any other discussion?
So David, question to you. You said specifically that, and I agree with it, what needs to happen is you have to dissolve both boards. Do you have to dissolve the corporation per se, or do you need to dissolve the boards and then have an entirely new revote versus, I agree with you. Everybody, you've got polarization on both sides of this issue. And, like I said, I've tried to stay friendly with all parties, okay? I tried to be, a kind of a peacemaker or peacekeeper here. And same thing with Mary and Paul. I have tried to reach out to you and ask questions. I did not talk to either party prior to this meeting because I didn't want to be tainted one way or the other. I wanted to hear, what was going to happen here. So from that aspect, we've got to go somewhere with this. I don't know if we have to dissolve the corporation completely, but we do need a start over. We need a start over point at some point, but we need to have, when you start getting into court, you don't make friends, and that's not a path to peace. Never is. And what you end up is you have a defendant and you have your other side, and it's just gonna blow up in our face in that regard for all those parties. I know Mary and Paul very much love being at the point, as well as my family. We don't come to the point, honestly, because of a lot of this, and plus we're ways away. Okay,
Scott, to answer your question, that's exactly why we're here. Because nice people like you don't come to the point because of the dysfunction, disruption. I hate to say it, there's lies, steal, cheat. You can't even make a reservation on both sides because both sides, you can't honor it. So it's gotten to this point, and you can't do it any other way. You have to get rid of the corporations to start over from scratch.
My
Because
question
this is not working.
Okay, with the dissolution of your corporation, theoretically, you're going to dissolve all shares.
I think we're discussing the corporations only, because.
No, but I mean,
No,
all I'm saying is, I'm playing devil's advocate.
They'll still own shares, same amount, nothing changes from that. We just, two business entities that don't agree trying to run one business. Because
I
in
agree.
the end, it fails. And I'm gonna not let it fail because these people go on forever back and forth. So therefore we start from scratch. Everybody retains their own ownership. Nobody can take away their ownership. It's just starting over again.
How does that work, David? Just tell us how that works. What's your game plan here? That's what Scott's first question was, is if you dissolve the corporation, then what's the next step? You gotta tell us.
Mr. Murray, listen, you have a very smart attorney that's sitting right next to you. And he can explain the process to you. I'm not your lawyer. But what I will tell you, as I said at the outset, our intent is, again, assuming this motion is successful and carries, is that we will be petitioning the court for judicial supervision of the dissolution. Okay? The court will oversee this. That is the intent to my client.
In other words, what they tell the court.
We want to have a transparent process. Any other discussion?
Make a call. Call it.
No, second my motion. Go ahead and second my motion.
She already seconded the motion. You need a motion to take the vote, close discussion.
Make the motion to close the, and call it.
Call the discussion.
Call the question.
I'll second.
Okay, we have a motion to call the question by Sue Scheiding with a second by Noreen Wilson. All right, all of those in favor of closing the discussion?
Aye.
Let's see, I have all ayes.
Aye.
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 Julie, do you want to vote?
Abstain.
What do you mean, vote on closing the discussion, or I don't know what you're talking about?
There's a vote to close the discussion.
It's just.
Do you want to vote?
Procedure.
Kurt, do your clients want to vote on that?
I don't know that you've called for nays. I just heard ayes. I might have missed it, Matt, I'm sorry.
Okay. And, all right. All those in favor signify by saying aye.
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 Those opposed?
No.
No.
Okay. So we're gonna make a roll call vote on this.
Yeah, I think there was at least one abstention too, just.
Yep. So I'm just gonna note it on, all right, ending discussion. Let's just roll call this. Mr. Yoset,
I voted no. Doctor.
It's a tough one.
you vote no, is that correct?
That is correct.
And sir, I show that you have 10 shares, is that correct?
That is correct.
All right.
And I'm sorry, Matt, to interrupt. To be clear, we're now voting on the initial motion, correct?
We're just, no,
We're voting to close discussion. I got lost.
yes. This is just a vote to end discussion. That's it. We're not voting.
Okay, I abstained, but whatever.
So you want to abstain. All right.
I was the abstention, yeah.
All right. William A. Murray. He's not there. Okay.
There.
Not present. Julie Murray.
She was here.
What's the point? I mean, what is it? If you vote yes, it just closes. If you vote no, what happens?
Then it would move to a vote.
Well, in theory, it would remain open for more discussion.
Well, how long can we have?
this isn't discussion, Julie, just you need to vote on whether or not to close discussion so that we can call the question on the underlying motion.
Oh, well, I'll always vote no because I think this is an issue we need to talk about for a long time to get it sorted out if we're,
Right.
reorganizing.
And Julie, you have one share, is that
I
correct?
have one share that was a gift from my grandfather. So, yes, I want to be a steward of the property.
All right. And Paul Murray,
Did you call for Paul?
yes, I did.
I say no, but what about all the other shareholders that didn't show up for this meeting? They probably didn't get notices, because I know there's a couple of them that didn't get notices.
Paul, what's your vote?
You said no.
You say no?
No.
And you have 10 shares, is that correct, sir?
That is correct.
All right. And Asher W. Murray. Not present.
He would definitely vote
Barbara.
no.
What's that?
He has chemo right now, unfortunately, and he would definitely vote no.
Oh, okay. Barbara Murray.
I'm sorry.
How do you know he got a notice?
Barbara Murray. You have her on a phone, right, Kurt?
We are on the phone here. Barb, the question, I don't know if you can hear the conversation, but the question that you are voting on right now is whether or not to end discussion. All right, do you want to end discussion on the motion? Yes or no?
No.
Barb votes no.
And Barb, you have 4 shares, is that correct?
Barb, you have 4 shares, is that correct?
Yeah.
Yes.
All right. And Mary K. Murray.
Yeah, I'm voting no.
All right. And you have 6 2/3 shares, is that correct?
I have 5 2/3 shares. My other son has 1. I gave it to him a couple years ago.
All right. You have 5 2/3. And what's your son's name?
Scott, and he did not receive any notice of this meeting.
Scott Murray. Okay. And okay. Then, as I stated, David Nielsen has power of attorney, and I'll go through each of these. So the first one I have is David Nielsen. How do you vote?
Yes, and discussion.
All right, and you have 29 2/3 shares.
Yes,
Next is Greg Honer. And I understand, Mr. Nielsen, you have power of attorney from Mr. Honer authorizing you to vote his shares. Is that correct?
yes.
And he has 3 1/3 shares.
And I vote yes for Greg.
Okay. Next, Sue Scheiding. How do you vote, Sue?
I never voted.
Okay, you have power of attorney from Susan Scheiding to vote her shares.
Yes.
You vote yes, and she has 14 2/3 shares. Is that correct?
He votes yes.
Next, Noreen Wilson, and you have power of attorney from Noreen Wilson to vote her shares. Is
Yes.
that correct? And she has 5 shares,
And I vote yes.
and you vote yes. Jennifer Hubner, you have power of attorney from Jennifer to vote her shares. Is that correct?
Yes.
And she has 7 shares.
I vote yes for Jim.
All right. Jason Murray, you have power of attorney from Jason Murray to vote his shares. Is that right?
Yes.
And he has 6 shares.
Yes.
And how do you vote?
Yes.
Shannon McKenzie, you have power of attorney from Shannon McKenzie to vote her share. Is that correct?
Yes.
And she has 1 share.
Yes.
And how do you vote?
Yes.
Brian Tobin, you have power of attorney from Brian Tobin to vote his shares. Is that correct?
Yes.
And he has 8 1/3 shares. Is that correct?
Yes.
And how do you vote?
Yes.
Dorothea Bates, you have power of attorney from Dorothea Bates to vote her shares. Is that correct?
Yes.
And she has 6 1/3 shares. Is that correct?
Yes.
And how do you vote?
Yes.
David Tobin. You have power of attorney from David Tobin to vote his shares. Is that correct?
Yes.
And he has 5 shares. Is that correct?
Yes.
And how do you vote?
Yes.
And Donna Kerrigan. You have power of attorney from Donna Kerrigan to vote her shares.
Yes.
And she has 6 shares.
Yes.
And how do you vote?
Yes.
So the tally for yeses, I show there's 91. And noes. Bear with me, I'm just doing some addition.
This is such a gross meeting. This is such a gross meeting.
What is it?
It's the point.
Mitchell Point?
So
The
I
point,
show
it's a
that
family
there
meeting.
is 91 yes
It's just,
and 20 2/3 no. Motion to end discussion carries. And now we'll move to the motion, the underlying motion to dissolve the corporation. And we'll call for a roll call vote for this as well. Scott, how do you vote? You're muted, Scott.
Sorry. I mean, I see both sides here, but I would have to agree that I would vote for the solution only from the aspect
they're
that we
gonna
start from
dissolve
scratch
it,
and
and then
get
I'm
this
sure
thing
he's
started on the
gonna
right
sell
field.
it. And everybody's just buying into his shit.
Scott votes yay. William A. Murray, are you present?
Say anything?
I'm
I'm
gonna have
actually-
to step out just a moment, please. Okay, I've got patients to see. I'll be right back.
I'm actually calling
What?
Willie right now to see if he can vote. He works as a school resource officer, so he's working today. But I'm calling him right now to see if he can vote.
Hey, this is Will. Leave me a message. I'll get back to you.
At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options.
Hey, Will, it's Julie. It's about, I don't know, almost 2 year time. If you get a chance, give me a call. They're voting on the lake stuff. Thanks. Bye. I left him a message if you could come back to him if he calls.
Right. And Julie, how do you vote?
Absolutely not.
That's a no, correct?
That is a huge no.
Thank you. And Mr. Paul Murray?
What is the question?
So now we're voting on whether or not to dissolve the corporation. It's a motion to dissolve.
Well, I would say definitely a big, huge no, because everybody, you're ignoring the bylaws and you're ignoring the standing rules. Everybody has to be paid to vote here.
Hey, Dad.
You can't just call this
So
like
they're
this.
doing the
Everybody
meeting.
has to be paid up in good
So
standing.
when they call for you, can I
And
keep you
half
on
of
the
those
phone
people
so you
that
can
you are
vote?
representing aren't.
That is correct.
Vote no, right?
So how can you vote and
Okay.
make this true
Hang on.
when nothing's set? You have to show the paperwork saying that everybody, who's paid, not paid, before you can even.
Okay, so then, this is Shannon, and so I wanna go back to Paul's statement that Paul just made. He just said that, how does he know that some of us have not paid? You and Mary Kay have also brought up that now Scott has a share. Scott does not have a share. Scott has not had a share for a while. That's my opinion, but on the books, no matter how you look at it, You guys say that we don't pay, we say Scott doesn't have a share. This is what has brought us here today. That's all I'm gonna say, because discussion was to have ended.
When Scott received his share, that would happen at an AGM, that all that paperwork went out to every shareholder out there. Everybody knew that Scott received his share at that time.
And Mr. Murray, you vote no. Thank you. Asher Murray, are you present?
He's on the phone.
No.
He's on the phone. Can you hear us?
Oh, great. Thanks, Julie.
He's right here.
Okay, and this is William A. Murray?
This is Asher Murray.
Okay, oh, Dutch.
Dutch.
You are present.
Yeah.
Okay. All right, and Mr. Asher W. Murray, you have 4 shares, is that correct, sir?
I can't hear him.
He said you have 4 shares. Is that correct?
Correct.
He says correct.
All right. Thank you. I have his no vote. Barbara Murray.
Barb, they're calling for you to vote on whether to dissolve the corporation. Barb says no.
All right. Mary K. Murray.
Okay.
I would prefer to be called just Mary Murray. The K is actually a nickname. It's not even my legal middle name. Thank you. And it's no.
Thank you, Mrs. Mary Murray. I apologize. All right. Mary, no, 5 2/3. All right. Have we heard from William Murray?
No, I just texted him. But what do you do when people are working today and would like to vote? I mean, what's the option?
We'll come back to that, and we'll
Okay.
go through the rest of these. Donna Kerrigan. Mr. David Nielsen, you have the power of attorney from Donna Kerrigan to vote her shares, correct?
Yes.
And she has 6 shares, correct?
Yes.
And how do you vote on the motion to dissolve?
Dissolve, yes.
All right. And Mr. David Nielsen, you have the power of attorney from David Tobin to vote his shares, is that correct?
Yes.
He has 5 shares, is that correct?
Yes.
And how do you vote on the motion to dissolve?
Yes.
Mr. David Nielsen, you have power of attorney from Dorothea Bates, is that correct?
Yes.
And she has 6 1/3 shares, is that correct?
Correct.
How do you vote on the motion?
Yes.
And Mr. David Nielsen, you have power of attorney from Brian Tobin to vote his shares, is that correct?
Yes.
And he has 8 1/3 shares, is that correct?
Yes.
And how do you vote on the motion?
Yes.
Shannon McKenzie, you have power of attorney from Shannon McKenzie to vote her share, is that correct?
Yes.
She has 1 share, is that correct?
Correct.
How do you vote?
Yes.
Mr. David Nielsen, you have power of attorney from Jason Murray to vote, is that correct?
Yes.
And he has 6 shares, is that correct?
Right.
How do you vote?
Yes.
Mr. David Nielsen, you have power of attorney from Jennifer Hubner to vote her shares, is that correct?
Yes.
She has 7 shares, is that correct?
Yes.
How do you vote?
Yes.
Mr. David Nielsen, you have power of attorney from Noreen Wilson to vote her shares, is that correct?
Yes.
And she has 5 shares, is that correct?
Yes.
How do you vote?
Yes.
Mr. David Nielsen, you have power of attorney from Susan Scheiding to vote her shares, is that correct?
Yes.
She has 14 2/3 shares, is that correct?
Yes.
How do you vote?
Yes.
And Mr. David Nielsen, you have power of attorney from Greg Honer to vote his shares, is that correct?
Yes.
And he has 3 1/3 shares, is that correct?
Yes.
How do you vote?
Yes.
Mr. David Nielsen, you have 29 2/3 shares, is that correct?
Yes.
And how do you vote?
Yes.
And have we heard from William Murray?
No, I have not.
Okay. So I show that we have 101 ayes and 24 and 2/3 nays. So the motion carries. Yep. So, and just FYI, well, this was a special meeting called for this specific purpose. The intent is to file with the Secretary of State a notice of intent to dissolve the corporation and then to apply to the court to have the dissolution conducted under the court's supervision.
Then
Thank you all for.
Can I just ask then what happens?
Again, that isn't. I'm not your lawyer.
I know you're not. I'm just asking. Then what? I mean, you're saying you wanted this all to create organization. What's the next step after that?
The next step after that is we'll get into court and have an orderly process.
I got a question about the power of attorney. What is that? Is it all those people signed a piece of paper saying that's power of attorney? It's not a proxy, right?
No, it's a power of attorney. Yes.
So basically, all those people signed their rights over to David for everything for this and continuing on. How far does that go?
They signed a power of attorney allowing him to vote their shares.
And that's the only thing.
Right.
He has that power. All right. Thank you all for coming on here. Have a good day. Meeting is
Thank you,
adjourned.
Matt, for facilitating.
Thank you.
Mr. Van Bruggen, does your representation extend beyond shareholder status, or is it also as representing the officers?